From Miami Law, I'm Annette Uguez, and this is The Explainer.
My big fear, and this is, I guess, taking us full circle back to where we started. My big fear is that this now, we celebrate justice and it fades into the background until the next terrible thing happens, right? I can't help but think of the parallel to debates about gun control, right? We have the mass shooting, everybody's upset. There's talk about passing gun legislation, and then just enough time passes that it fades into the background, and then the next one happens. And it's like, oh, why didn't we do anything before? We'll do something this time.
Welcome to the last episode of Season 6 of the Miami Law Explainer, the legal affairs podcast where Miami law experts lend context and historical relevance to today's headlines. As former Minneapolis police officer Derek Chauvin awaits sentencing in the murder of George Floyd, Miami Law's criminal law expert and former special assistant U.S. Attorney Scott Sundby explains the processes. Let's go to executive producer Catherine Skip with the interview.
Good morning, Scott. Nice to have you back.
Good morning. Good to hear your voice, Catherine.
Ditto. So first, why is the verdict a watershed moment? Like, why or why not?
I think we have to wait and see. There's some reason to be optimistic that this is a true change in sort of the stream of events, and that we will get much more serious about police abuse, especially of minority members of the citizenry. But we have to keep in mind, Catherine, this was a very unusual case in the strength of the prosecution's proof. I mean, they had a 10-minute video from 8 different angles that was just very powerful in a sad way, but undeniable. They had eyewitnesses who were very compelling and backed up by the video evidence. They had a victim who came across as very likable and loved by his family and friends. They had great expert witnesses who were able to sort of preempt the defense's line of saying, oh, this was a medical event, not a police-induced fatality. And I mean, I've listened to a lot of experts. These were, especially Dr. Tomlin, I fell in love with. I just thought he was superb the way he taught the jury about pulmonary processes. So we had a case where, the prosecution still had to weave a narrative, and I thought they did so impressively. But they had such an array of rich sources to draw upon. So I hesitate to say, so if you had asked me if they had acquitted, would I view it as a watershed moment? The answer probably would be yes. If you can't get a conviction in this case, then let's just all pack our bags and go home, right? But it makes it hard then to say, well, is this truly a change that's coming about? And I guess one other thing, Catherine, in talking about, is this a watershed moment, is that to get real meaningful reform, it has to go deep. So it's not something like the push for gay marriage, where once the Supreme Court said it was constitutional, then you had it cemented, right? Here, even though we're now, I think, as a society, acknowledging problems with policing, especially of minority communities, it is something where you need deep systemic reform. You need to get rid of qualified immunity so that civil suits actually stand a chance. That's a whole different podcast, by the way. We need to really start talking about what we want with policing, right? Get them out of the business, which most police officers will tell you they don't want to be in, such as responding to mental health calls, even traffic enforcement. That's not why a lot of people sign up to be police officers. And yet we, find that it's those interactions off of traffic violations that lead to so many of these abuses. Now, often those are pretextual. They're not really interested in the air freshener on the back or the rear window mirror. They actually want to sort of see more about the person driving, which is usually because of the color of their skin and their
Right.
age
Driving
and
while
all.
black. Right.
Driving while black, precisely. But we there are things that we could do that would, I think, improve it considerably. But unless those things get done, I fear that this will not be the watershed moment that it otherwise could be.
Right. Right. Um, there seemed to be, well, one thing I wanted to ask you about when you were saying, like, this was the perfect setup, and if you can't get it here, you can't get it anywhere. Also, early in the game, the case was transferred into a higher prosecutorial uh, role, and that seemed to like ramp things up a little bit. But also, I wanted you to talk a little about the makeup of the jury and how that contributed. It seemed there was a marked difference from other juries in police killing cases.
So, there's relatively few prosecutions of police officers. So, as a social scientist, one hesitates to say, well, this is the usual makeup, right? Because there's just not a lot of cases to compare it to. So many of the cases, like the Breonna Taylor case, don't even make it out of the grand jury. So you don't even have trials, right? And so it's a little hard to say, well, what is the typical makeup? And of course, typical makeup of a jury in any one county or city is going to depend upon generally the makeup of the population pool. So this is unusual, at least in this sense. The population of Hennepin County, where this took place, is about 74% white and only 17% people of color. The jury was 50% non-white. So that is unusual. So even without taking into account other counties or excuse me, other police prosecutions, this would be unusual to have such a robust representation of minorities on the jury. And there's a couple reasons that probably happen. One being that, as you may know, the Supreme Court back in 1986 handed down a decision called Batson versus Kentucky, which said that you cannot strike individuals because of race. There are many of us who have been very skeptical that that has been enforced in the way that the Supreme Court thought it would be enforced. But in a case like this, where any challenge by the defense of a minority juror, so and by challenge I mean a peremptory challenge. Each side is given a certain number of challenges that they can use for any reason other than race or gender. And then there's this whole process as the judge has to decide, well, was it really because of race? And often, on very dubious grounds, they decide it is not. But in this case, where race was so front and center, I think it really probably kept the defense attorney from exercising peremptory challenges on minority jurors, potential jurors, because of the concern about Batson and how this might work. So I think, again, because it was in a spotlight, a national spotlight, that might help explain why we ended up with a jury with so robust a representation of minority jurors.
Hmm. Um, while we're throwing around terms, we heard a lot during the proceedings about the Blakely factors or Blakely trial or Blakely hearing and Blakely waiver. What does that mean, and why did it or does it matter in this case?
So can I just say, when I heard the phrase Blakely factor being thrown around, it's like, oh man, sometimes it's good to be a crim pro nerd, right? I may be one of the few people in my neighborhood who knows what that is, right? It
Totally
comes
love that you're a crim pro nerd.
right. Well, yeah, there are worse nerds to be, I guess, but
Yeah.
and worse non-nerds. But um, so Blakely factors are called that, and not all states call them that, but off of a Supreme Court case called Blakely versus Washington. And it was a decision which said that if you are going to increase a sentence above what would be the normal sentence, a jury has to find the facts which justify that higher sentence. This was actually something that Justice Scalia really pushed. And you want to talk about another interesting podcast, we could talk about the late Justice Scalia, who was a very complicated and fascinating justice. But one of his big things was, juries are central to American criminal justice. And it used to be before Blakely that you would convict someone of, say, basic second degree murder, as it's here. And then the judge would say, oh, by the way, I happen to find these extra factors, which were never argued to the jury. The jury never had to find. And I'm going to give you a much higher sentence. And the defendants, of course, going, well, what about the jury? I thought I had a right to a jury. And Justice Scalia said, yeah, you do when it has that type of impact, essentially making it even a higher offense than what the jury convicted you of. So those are the Blakely factors, sort of these special sentencing factors. In this case, it would be things that like there was a particularly vulnerable victim, or it was done in a particularly cruel fashion, or that there were children present because there were some minors who were watching Chauvin with his knee on George Floyd's neck. So those would be Blakely factors, because if those are found, it allows the judge to go higher in the sentence than he or she otherwise would be allowed to do.
Okay. Hand in pocket throughout the interchange. I don't know. That would be definitely a factor.
Well, so yeah, and that would probably be argued as showing that this was particularly cruel, if you will. Or another one is abuse of government authority. Uh, and so you're going beyond what you're allowed to do, which we now know the jury certainly found, right? That this was not a lawful use of police force. So those are the Blakely factors, usually found by a jury. Here, the defense waived the jury. Um, Probably makes sense from a defense perspective, in part because if they're coming back guilty, the jury's already sort of very much against your client. And some of these, I could see wanting a judge, especially someone like Judge Cahill, who comes across as sort of a very by the book, this is what the law says, and I'm not going to stretch it. Some of these terms, he might not be quite as shocked, having been on the bench for a long time, as to what is cruelty or a particularly vulnerable victim. So I don't know. I have no idea to know what Cahill will rule on these, but it's not irrational by any stretch for the defense attorney to say, I'd rather take my chance with these with the judge rather than the jury.
Well, is Minnesota sort of unusual in that a sentence doesn't stack, that they only sentence on the most egregious charge, whereas I think in other places you get, 10 years for this, 10 years for that.
Not really. So often what happens is some of these charges. So essentially, if you think about what was charged, Catherine, it was really sort of giving the jury a cascading, descending options. So there was second degree murder. And if they didn't find that, they could have then found third degree murder, which is a lesser charge. If they didn't find third degree murder, they could have found manslaughter. So, from the prosecution's viewpoint, it's sort of making sure there will be a conviction, right? Again, the evidence was very strong on second degree murder, but you're building in sort of those insurance policies. And sometimes, depending how they're defined, we even call those lower charges lesser included offenses. And the idea is that they kind of fold into the higher offense, because otherwise you're really punishing someone, depending on how the sentencing structure is put out. But if each one is punished separately, you're kind of punishing someone, in this case, 3 times for the same behavior, which was using unlawful force on George Floyd. And double jeopardy is one of those concepts like 3 people in the world understand. It's sort of like the theory of relativity, right? But so this, depending on how it's defined, you might even have double jeopardy issues. So Even though states vary as how they do it, it would be very unusual to have sort of three charges off of the exact same behavior um, stacking in a way. What some states would do is they might allow sentences for all three, but they make them run concurrently, which means that it's the exact same thing. So the overall end result is not unusual, I guess, is a very long answer to get to a short answer.
Not like the movie Double Jeopardy. Well, Cahill has immense latitude in sentencing. Um, so in this case, the felony second degree murder has a maximum sentence of 40 years. So how far up or down could Cahill go?
Yeah, so this is something again. It's really easy to hear the overall sentence, right? Gosh, you could get up to 40 years and think there's a lot of latitude. That latitude is, and it used to be actually that way. There's some old cases where the sentence would be 1 day to life. You want to talk about sort of discretion, right? And over time, especially starting in the 1980s, there was a real concern that judges had too much latitude. That, again, often based on the color of the skin, one person was getting a year, the other person was getting 10 years for basically the exact same behavior, right? So we've moved largely in the United States. And again, part of the problem talking about this is there's 51 different systems, right? The 50 states and the federal government. But by and large, we have moved to what are known as sentencing guidelines, which are meant to sort of at least guide, in some states, really contain what sentences can be handed down. So I am not an expert by any stretch on Minnesota sentencing guidelines, but my understanding, looking at it briefly, is that basically he's looking at a 10 to 15-year sentence. The presumptive sentence is 12 and a half years. And if he finds that, as Judge Cahill, Blakely factors, what we just talked about, it could go higher than that. But that is basically, you really have to justify. So if we say a presumptive sentence, you're going to have to justify as the judge making that higher. So I would push back a little on the saying that he has immense latitude, because he actually doesn't, in the sense of, well, this feels like a 30-year sentence to me, right? He's got to go within the guidelines. So depending what happens with the Blakely factors, we're probably looking at something in the, probably 15 to 20-year range at I would guess at the maximum. And if I prove wrong and he gives a 40-year sentence, can we go back and edit this out? But anyway, that's how the guidelines in theory are supposed to work.
Right. I mean, 12 and a half years for a white cop killing a black man in prison is probably pretty hard time.
Well, right, and he's in administrative housing right now. This is going to be a tough go for Chauvin. There's no doubt about it.
Yeah. So there was news that it broke this week on a federal prosecution for a violation of Floyd's civil rights under color of law. What is this, and what could be the potential fallout?
So there's two aspects of a federal role here. One is to actually prosecute. So if you violate, even a state police officer, if you violate someone's federal civil rights, that is a crime. And it is often used as sort of a backup if the state prosecution fails. So for those of you out there old enough like me to remember the beating of Rodney King, and one of the first times that at a national level, police abuse of minority members got attention. This was two on video, right? And there was a state prosecution talking about juries and how they influence us, Catherine. That case, which actually happened in LA, was moved up to Simi Valley. And Simi Valley was a very white ex-military population. And the jury acquitted these police officers who had beaten Rodney King, and we got the LA riots. And what happened then is the federal government stepped in and prosecuted those police officers for violation of Rodney King's civil rights. The trial took place in LA. It's a different jury pool as well when you have a federal case. And they got some convictions of the officers in that case. I have not heard that there's actually going to be a federal prosecution in this case. It's still possible, but it's probably less likely now that he's been convicted. What the federal government also can do, and which I know they are doing, is what's known as a pattern and practice investigation, which is that they will go in and they will review, in this case, the Minneapolis Police Department, and come up with all sorts of recommendations and findings, and then that the Minneapolis Police Department will need to follow. And if they don't, then there can be civil lawsuits and judicial orders obtained to make them do that. You may remember that this is what happened in Ferguson, Missouri, and there was a very interesting, important, and disturbing report that came out of that was done by the Department of Justice. And this was actually prior to Trump, a fairly, common is probably too strong a word, but many large cities especially had their police departments go under these types of reviews where there were problems. That kind of ended under the Trump era. Now, Attorney General Garland has indicated that I think he's going to be stronger in pursuing this.
So I don't know if you have, let me start that again. I know you don't have a crystal ball, Scott, or I don't know, maybe you do. But how does this verdict bode for the other three officers with their trial in August?
So I do have a crystal ball, but I use it only for day trading on Wall Street. And I try to keep it very specific. So I won't use it on this. But yeah, it's really, that's a interesting question, tough question, Catherine, because the basic idea is these are the officers who were around Chauvin, right? And they are now being charged on an aiding and abetting theory, what we sometimes call being an accomplice. And the physical aspect of that charge is clearly going to be found, which is that you basically help the person commit the crime. So if I hold the ladder for you, Catherine, while you climb up into your neighbor's second floor because they've got a really nice big screen TV, you are guilty of burglary. I'm also guilty of burglary because I aided and abetted you, right? The problem for the prosecution with this is you also, though, have to show that they had the mental state, what crim pro or crim law nerds would call the mens rea, that they also had the mental state required for the crime. And in Chauvin's case, it's basically he intentionally used deadly force that he was aware, was capable of causing death. And so the different roles might play a part of this. So I know there was one police officer who was across the way. I don't even know. I don't know. I'm not casting judgment because I don't know whether he even knew that this was happening in the sense of Chauvin having his knee for all that time on Floyd's neck. I don't know what his viewpoint was. So that might be a part. One thing which, if I was the defense attorney for these police officers, I'd really be looking into is, as I understand it, Chauvin was their commanding officer or the senior officer, and some of them were quite junior in terms of having been police officers. And there's going to be a dynamic there where I know that at least at one point, one of the officers said, gee, should we get a police? Should we roll him on his side? Should we get another ambulance or whatever? And Chauvin's like, no, right? It's the ambulance is on the way. It's all fine. Yeah, I could see as the defense attorney, saying, hey, listen, this guy, is junior. He's being told, I've got it all under control. Everything's fine. It would not be, unreasonable for him. I'm not saying this is how I'd find. I just keep the hate mail off, right? But I could see a defense attorney saying, hey, listen, he didn't understand that this actually was posing a deadly force because he's thinking this guy's been a police officer for 20 years. what do I know, right? So again, there are dynamics to it, which I wouldn't be surprised if there may be the jury find a lower, something like the manslaughter charge or the third degree homicide charge, based on each police officer's role. So, and if it's a joint trial, which is what I think at the moment it's scheduled to be, that is all three officers being tried at the same time. How their different roles play in also might benefit some and hurt others in the jury's eyes, right? So my crystal ball on this, if I had one for this, would be very, very clouded because it's going to be, I think, a far more complicated case from the prosecution's viewpoint than Chauvin.
Uh-huh. This last question you've touched on partially earlier in the show, but what do you think the verdict means in terms of the future of policing and holding officers and, in this case, police departments accountable?
So I do think that it is sparking a national conversation, which is very, very needed and very helpful. I think it's oddly good that it happened in Minneapolis. If this had happened in a city in the deep South, I think there's a fair. I grew up in the Upper Midwest, and so I sort of know these attitudes, right? And there would be many people are like, well, yeah, of course that happened in Houston or Atlanta or Charleston. That's what happens down there, right? It's in Minneapolis, which really prides itself on sort of being this, relatively liberal hipster city. And it turns out that Chauvin is not by any stretch an anomaly, right? There are real problems with the police department. I think it's makes everybody sort of sit up and go, whoa, there are problems with policing generally. And again, when I say that, I don't want to sound anti-police because we need police, right? You want a police officer when you are there's a burglary or people are attacking a demonstration. What we really need is that conversation of what is it that we want the police to do, and how do we limit the situations where they are involved, where these things could happen. And one other thing, Catherine, that people don't often understand is that who becomes a police officer and the training they undergo varies dramatically from jurisdiction to jurisdiction. There are some states, some cities which have very impressive police academies and training. There are other areas where you can get hired with minimal training, especially when funds are tight. And so, a conversation that we've never really had in the U.S. Um, is, should we have some type of uniform requirements for police officers that would help us ensure that we have officers who are well trained and understand things like the use of force in a smallish country like the United Kingdom. You have a central police force. You have uniform training. Of course, there are very few officers can carry guns. So there are ways that we can have a conversation which is needed. My big fear, and this is, I guess, taking us full circle back to where we started. My big fear is that this now we celebrate justice and it fades into the background until the next terrible thing happens, right? I can't help but think of the parallel to debates about gun control. Right? We have the mass shooting. Everybody's upset. There's talk about passing gun legislation, and then just enough time passes that it fades into the background, and then the next one happens. And it's like, oh, why? Why didn't we do anything before? Well, do something this time, and then time fades, and so this is also It should not be a partisan issue. That is proper policing. I mean, everybody is affected by it. But I'm afraid it's going to be turned into one where either you're pro-police or you're anti-police. And if we fall into that conversation, I am very pessimistic that anything of meaning will be done, other than perhaps in a few cities. I know Berkeley and Ithaca, New York are doing things, but those are sort of like, if we're going to stereotype, that's the Birkenstock crowd, right? And my fear is you're just going to get that, and bravo to them, but we really need to have a conversation with serious people on all sides of the political aisle. And my fear is that that's not going to happen, right? That some demagogue is going to get up and running for president, say they're after the police, they're anti-American, and once that starts to happen, it becomes an issue like every other political issue these days, bogged down in partisan, and shouldn't be partisan squabbling. I mean, police reform is really necessary, and even police will tell you that.
Uh-huh. Well, another helpful podcast with Scott Sundby.
Thank you, Catherine. Great to talk with you as always.
Thanks again for joining us. I'll see you around.
All right. Ciao.
Thanks, sir.
Thanks for joining us at The Explainer for Season 6 and another season of interpreting legal issues in the headlines. We will return in August, but stay tuned for some summer bonus episodes. If you love our show, leave us a 5-star review with your podcast provider and ask your friends to subscribe. You can always drop us a comment at explainer@miami.edu. Our show is engineered and edited by Christopher Alzadi, with theme music composed by Rady Kim from the Frost School of Music. I'm your host, Annette Uguez. Today's episode is brought to you by Miami Law's annual Bankruptcy Skills Workshop on June 2nd and 4th. The virtual workshop focuses on the current direction of consumer bankruptcy and other complex financial issues. For more information, visit law.miami.edu.